All right, well, thank you. We wanted to welcome you to the University of Baltimore and thank you for speaking with us today. This is Professor Camargo. If you would like to just tell us a little bit about yourself, where you came from, and what you're doing here in the United States.
Okay, thank you very much for the opportunities. I'm very glad to be here with you. And I live in Brazil, in Rio de Janeiro. I'm a professor of the Federal University of Rio de Janeiro, professor of theory of law. And I've been studying for a long time about hermeneutics and interpretation of law. And I focus my research in the decisions of the Supreme Court of Brazil, and I study a lot in Brazil. We study about the North American system, and also the decisions of the Supreme Court of the United States. And now I'm here in New York. I came to New York. I stayed in New York for 8 months as a visitor scholar at Fordham University. And I'm here, I'm making a comparative study between Brazil and the United States about the use of scientific arguments in law, especially in the Supreme Court. Because nowadays, more and more often, the justice need information about other fields of knowledge, not more than the law offers. And for instance, the role of the amici curiae is so important. More and more, the number of amici curiae is increasing here in the United States. And in Brazil, you have the amicus curiae also, but you have something called public hearings, and when the justice call the experts to know something, to have more information to decide. And then I think that's a movement we can find here and there, and it shows that how the arguments, the facts, the information come from other fields. Is important to decide, for the judges to know the subject they are dealing with. And that's what I'm doing here. When I came, I followed the problem of evidence, the problem of facts. Now, how the facts in the real world affect the decisions in law. How this kind of facts that usually the scientists shows, or it exists. For instance, the asbestos is something really little. The asbestos is something that causes cancer or something exactly. And then the justice, knowing it, having this information, will decide that the dealing with asbestos is something that the Constitution forbids. And how, since then, from then, many problems we can face. And I'm stressing a distinction that we can find in the theory of law, actually among the proceduralists, the scholars of procedural law, again, difference of adjudicative law and legislative law. These two expressions were coined by Kenneth Cope Davis.
Adjudicative facts and legislative facts.
Adjudicative facts and legislative facts. These two expressions were coined by Kenneth Cope Davis in 1942, and until nowadays they are reference for this kind of discussion. The federal rules of evidence in the Rule 201 put aside expressly legislative facts of the consideration. And I think that it's the advisory committee, the notes that follow the text of the law, mention Kenneth Cope Davis many times. And then I'm authorized to take these two distinctions. Okay, and legislative facts is something when facts I use in a different way. Okay, facts are facts always. I'm trying, because there's a question of matters of law and matters of fact. Everybody knows that matters of law, matters of facts. Matters of law is something that the judge has to face and decide. matters of fact is something to the fact findings in a trial, for instance. Okay, and the facts usually are considered for the scholars only in adjudicative approach. What is it? Looking for the past. What happened, when, how, and what happened. To apply the law, to say if someone is guilty or is not guilty. But I want to say that the courts not only apply the law, okay, over what happened in the past. At the same time, the judges make a new law, a new rule. When they decide, even mainly if you consider your system, the system of the precedents, the common law system for the precedents, and they know that from then on, that decision will be must be followed, and it's much more if it comes from the Supreme Court. And then my point is, if at the same time as the Supreme Court is applying a law, because here in the United States, to provoke the Supreme Court to say something, it must be a plaintiff and a defendant, parties. Okay, but these parties, the decision, of course, will not only affect the parties. The decisions will affect everybody from then on. And so the facts, the same facts that the judge used to apply the law over something that happened in the past, they also use that facts for the future. And then the same facts are used as legislative, okay, in this approach. And my point is, it's time to take it into consideration. And it's a big problem because the federal rules of evidence put the legislative facts aside. And so the proceduralists don't take them into account, and it causes some prejudice because the theory of law cannot face the problem of the change of the predicates of the rules, the norms, to see and to give response when the same text of law have a different meaning, a different scope. For instance, the equal protection of law of the 14th Amendment. Before Brown Board of Education, separate but equals were okay. But after Brown Board of Education, the same text, the same 14th Amendment say something different. How can we explain? Of course, we can explain because the new facts shown from some experts change the predicate of the fact, and so the rule changed. It's a problem if you consider legislative facts or facts used in a legislative way. We can give a response, a good response from this. And others and also for the judicial review or the constitutional field. If you don't face the legislative facts, we cannot know how the courts are actually using them and in what measure the court has authority to defer the knowledge for this kind of experts or the expertise coming from the legislator must be taken into consideration. Anyway, then there is a problem of the judicial review. Who has the power to take into account legislative facts and who has the power of the last word and about the Constitution?
So that was kind of a nice summation of everything you talked about today, basically that the legislative facts and how they should be applied correctly to the court procedures.
Just how they should be considered, acknowledge that they exist.
Acknowledged in the system because they are there and we just haven't been considering them when we are making judicial decisions. What are some of the most important points you think from the lecture that you gave today to kind of as a takeaway point, something we should be realizing and maybe something that we can move forward with?
Okay. I think that would be a good idea to call the procedure scholars to take into account or try to extend the scope of the 201 rule of Federal Rules of Evidence. And so I think that also the constitutionalists and in the field of jurisprudence, we could have profit because of this. And then I think it's time to focus in the scope of Rule 201. Okay.
And then do you have any other comments relating to your research or anything that you wanted to give to United States students and lawyers? And it can be anything maybe that you've researched or learned that you think we should learn here in America.
I think it would be nice to take into account what happens in other systems. Also, Brazil, for instance, is my country, and even in Europe, I think that we have great advances in there is a professor, philosopher of law called Robert Alex that's facing this kind of problem in the field of interpretation of the law, and take a look what has happened in other countries, how the other Supreme Courts are deciding, different systems, from comparing the amici curiae and the problem of the public audiences, because probably something that is affecting many countries in the field of the judicial review at the end.
All right, well, thank you very much, and we are glad that you came to speak with us today.
I'm so grateful.